Folks, we are in the license law and commission rules section, and that is where we are going to pick back up. This is North Carolina specific things that are potentially testable on the North Carolina specific portion of the test. And so we've talked about trust accounts. We've talked about license statuses. We talked about active versus inactive, current versus expired. We talked about the commission's composition, 9 members, 2 can't be brokers, 3 have to be, 3-year terms, what they can do to your license. All of those fun things. And we left off on this one. And we didn't really talk about this last night. Proof of license. Rule 58A.0101 says that as a licensed real estate broker, you would have to prove that you had a broker's license if asked to do so. No, you do not keep this on your person anywhere you go. That would be ridiculous. You have what is called a pocket card. A pocket card is basically a miniature identification of your name and your license number and your status, whether you're a PB or a full broker. It used to be that they mailed them out. What you got, Raphael?
Just a question, a simple one. When can you have a business card?
When you can have a what?
A business card.
When you were lawfully allowed to advertise. So if you're a provisional broker, once you affiliate with a broker in charge.
So as soon as you have a BIC, then you can have a business card and spread them out.
Yeah. Yeah. Because you can't advertise unless you have a broker in charge, right? And so once you have one and you're an active broker, you can advertise. Folks, to the point, Brooks, I'm starting to wonder too if that's Diet Coke, man. I'm struggling today. So to the point, and please don't think that you're going to get in trouble for this, but maybe don't do it. If you were to pass the state licensing exam and they mailed you your license, if you were to post a picture of that on Facebook and said, you're looking at the newest licensed broker in North Carolina, technically that's illegal because you just advertised illegal brokerage activity because you're inactive, right? You have a license, but it's inactive until you have a broker in charge. So once you have a broker in charge, they'll order you business cards. You can pass them out to your heart's content because then you'd be active and have the ability to advertise. Good question.
So I can't tell nobody I passed?
You can say, I passed my real estate license, but maybe don't advertise yourself as a real estate broker. Or I passed a real estate exam. Maybe just say that. Once again, do you think that the real estate commission is throwing people in real estate jail for that? No, because you probably don't know any better, but it technically is not appropriate because of the way the laws work. What you got, Parker?
How many brokers are in the real estate commission? 3?
There has to be 3. It can be more than that, but there has to be at least 3 that are real estate brokers and at least 2 that are not at any given time. But as long as that criteria is met, you could have, 7 that are real estate brokers as long as 2 are not. And you could have, 6 that are not as long as 3 are, as long as those criteria are met. Yeah, good question. What you got, Beverly?
At what point can you set up an LLC after aligning yourself with a broker?
You tell me.
So at any point in time?
Nope.
Essentially.
Nope.
So after you have met the criteria?
What are we?
The 3, the years of experience, unless you're a sole proprietor?
Well, hold on. Let's clarify something. What are you creating the LLC for?
So if you wanted to create the LLC for property management purposes, but you were affiliated with the BIC, could you do that? And could you have a separate LLC? And
no, because you would need a BIC of that entity. Every office, every entity would have to have its own BIC if it's doing brokerage activities. And so just having a BIC wouldn't allow you to create one because your BIC's not supervising that one. Your BIC's supervising theirs.
Okay.
Yeah. So what we said yesterday, if you're creating an entity for compensation purposes only, the criteria is just a full broker, as Bree said in the chat, because a full broker can be the qualifying broker, the person who's the owner that qualifies to get the firm license. Could you create an entity as a full broker? Absolutely. But could you run your own property management through it? No, because your separate property management, if you're advertising it and it doesn't have a BIC, you're doing it illegally. And your BIC of a sales firm or even an affiliated firm is going to be managing their brokerage firm, not yours, and they can only be the BIC of one at a time.
So it's not basically hanging your license there, and that's the affiliation. It's the BIC is actually affiliated with that particular entity.
Yeah. So, for example, if you get your license tomorrow, and let's just talk about HPW because we just had them as guests. If you go and you hang your license at the HPW Holly Springs office, it's a good friend of mine named Glenn Weeks is the broker in charge there. And so you're now part of Coldwell Banker HPW, and you're affiliated for sales purposes in that regard. Now, if you went to like HPW's property management brokerage, you'd be affiliated with Greg Beck, and you'd be doing property management under his entity, right? Or the company entity that was doing property management. His existence, his mere presence wouldn't give you the authority to create a separate one, because the separate one would also have to have the means to advertise, meaning its own BIC.
Okay.
Yeah.
Gotcha. Thanks.
Yep. Oh, good questions. So, proof of licensure, nothing too crazy here. You have to carry around the pocket card. It used to be a physical piece of paper. Now it is just a digital thing. You can go to the Real Estate Commission's website. There's a login. You can download it. So it's very easy. Also, firms also have a pocket card. So the qualifying broker that we just talked about would be the one responsible for carrying the pocket card of the individual firm. One last word of caution. I don't remember if it's on your test or not, but just in case, the firm license has to be hung up in the office location, the actual physical one. But our licenses do not have to be hung anywhere in a firm. When we say you hang your license with a BIC, it's a figure of speech. You don't actually hang it up. Everybody with me? You can hang yours on your wall and you just carry on your pocket card. The only one that's actually required to be in the physical office location is the firm license. That would have to be actually hanging in the office location. Actually, it's miserable. Okay? It's absolutely miserable. I just can't get over it. It's so bad. So I'm going to go ahead and group a couple of rules here as well, folks. I know there's so many dates for you to memorize throughout this class. It's cruel and unusual, but one of the big testable rules for North Carolina is when you've got any kind of name change, address change, basically contact information change, okay? There's a rule that states if you change your name, your address, your affiliation, right, you get your, anything like that, you have to notify the commission within 10 days. Well, they're responsible for you, and they need to know where to find you if you get in trouble. So they will need you to keep that up to date. So if you get a question that says the BIC's responsible for notifying the commission of this, no. It's you. It's your license. You are responsible for notifying the real estate commission if you get married and your name changes, if you move, if you have an address change, all that stuff within 10 days. Okay, 10 days of any change. Now, there's another one, please don't get these confused, that says that if you have a criminal conviction, you have to report that to the real estate commission within 60 days. And then let me clarify stuff. This is part of the reason why you have to have a background check. They check your record when you get your license to make sure you have that requisite character, but they're not checking, you're not doing background checks on a regular basis. And so I like to call these self-policing rules, where they say you got to tell on yourself if you have a criminal conviction. But here's the clarification. A conviction is not the same thing as an arrest. If you get arrested for a DUI, that's an arrest. You don't have to tell the commission. If you have your day in court and you're found guilty and convicted of a DUI, you now have 60 days from that conviction to report it to the real estate commission. And it's not just convictions. It would be a conviction, a disciplinary action by another licensing board, a military court-martial, or anything like that. So let me give you an example test question. Sam is a licensed real estate broker in North Carolina and South Carolina. Sam gets in trouble with the South Carolina Real Estate Commission. Which of the following would be true in regard to Sam in North Carolina? He would need to report the disciplinary action with the South Carolina Real Estate Commission within 60 days to the North Carolina Real Estate Commission. And please be aware that the North Carolina Real Estate Commission can potentially take your license if they see fit based on the other state's disciplinary action. Raphael says, reckless driving, if it's a criminal offense and you're convicted, yes. Of course, like what would you call non-moving violation or just a speeding ticket that's not over like a criminal level, that wouldn't be. But if it gets to the criminal level and it's conviction, then yeah. What you got, Brad?
So you list all these rule numbers in here. We don't have to know these by the
Nope.
rule number.
Nope. None of your numbers are testable on pre-licensing.
Cool.
Yeah. Good question. None of the numbers are testable even in post-licensing, if we're being completely honest. Brad, if you called up the real estate commission staff and asked them to spit out some of these numbers, half of them couldn't do it. Of course, nerds like me that teach this stuff 80 hours a week, I mean, I know a lot of them off the top of my head, but it's a party trick, a very, very lame party trick. It does nobody any good, except it makes it easier for me to refer back to the material if I need to show y'all where a rule is by remembering what number it is. So 60 days for criminal conviction, military court-martial, or disciplinary action by another licensing board. Here's a question for you folks. True or false? North Carolina real estate broker must physically display their license in each office they are affiliated with. No, there you go. False. They have to be able to produce their pocket card, but they do not have to physically hang their license. I told you, when we talk about affiliating with a firm or hanging your license, that's a figure of speech. The firm license has to be physically hung up in the office location, but the individual broker's license is not. I mean, honestly, you could just put it in a filing cabinet if you wanted to. It's just, you work so hard for it, a lot of us hang it up somewhere. So we've already talked about this in great detail. The CE discussions, of course, you have to take CE after your first renewal, or in other words, in your second renewal year, right? Prior to the second renewal. 4 hours of update, 4 hours of elective prior to June 10th. If it's your provisional broker or a full broker, we call your update Gen Up. And if you're a BIC or BIC eligible broker, your update is called BIC Up. Do not confuse that with the 12-hour broker in charge course. And if you fail to take your CE prior to June 10th, what happens to your license and when? There you go. Nailed it. Inactive, July 1. Inactive, July 1. Love it. Now, folks, a lot of these next couple things, this is really just going to be review stuff. We've already taught you agency in every way, shape, or form. So I'm going to go through this a little bit faster, and we're just going to call this part of our review. Remember, when we're dealing with the working with real estate agents disclosure, for the love of all things sacred, I can't tell you how many students screw themselves over on the test because they do not remember keywords. First keyword to remember is that the working with real estate agents disclosure is required in all sales transactions only. Look me in the eyes, get weird for a second, folks. There is a test question, multiple probably, on your North Carolina licensing exam for me that you will take next week. And the answer choices for the working with real estate agents disclosures, two of them come to mind. One says all transactions, one says all sales transactions. If you pick all, you have screwed yourself. Is everybody with me? Because all is an absolute. At least when I say all sales, that's actually not really an absolute. It's a very specific category. But that is something that each student's alive on the test. Not all transactions. It's not required in property management. It's not required in working with tenants. Sales only, both residential and commercial. Remember, too, the trigger for disclosing or giving somebody, by the way, it's always tested as a written disclosure. You have to give them that physical copy of the document that we reviewed with you. And we have to review it with them and give them a copy. And the trigger is first substantial contact, which means at the time the conversation starts going to confidential information. So do we always have to give somebody one of these? No. If we're holding an open house and the conversation never goes there, we didn't have to give them one. But the second that the conversation starts going into price, terms, motivation, anything deemed confidential, we would have to stop them, review the working with the real estate agent's disclosure with them, and we ask them to sign it just to acknowledge that we've reviewed it with them. Do they have to sign it? No. So if you have a test question and one of the answers is they have to sign it, also not going to be the answer. They do not have to sign it. We ask that they sign it, but what are you going to do if they don't? Nothing. Have to keep copies of this for 3 years from the date of last activity. If you help them buy a house, that would be the last activity once that closes. If you meet them, give them this, and never talk to them again, that'd be the date of last activity. So 3 years, and there's never, ever, 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 ever creates an agency relationship. Never, ever. What you got, Brooks?
So if we're required, hypothetically speaking, if we're required as real estate agents to go over the Working with Real Estate Agents Act, and they don't sign it, does that mean we can't work with them, or is it a non-legally binding just thing that just says, hey, we informed you of it and this is protecting you and me?
There you go. We absolutely can still work with them. Folks, understand, to Brooks's question, they absolutely could sign a buyer agency agreement to work with us, even if they don't sign a working with the real estate agent's disclosure, right? As long as we know we reviewed it with them, that's just to show that we were in compliance with the laws. But if they refuse to sign it, we would just note that and we could move on. I mean, it's not the end of the world. We absolutely can still work with them even if they don't sign it, because this was never forming a relationship at all. The signature just it shows that we are in compliance. But if we make a note that they refuse to sign, we're not going to be in trouble. Now, there was a time where agency disclosure had to be made with a different trigger than this. What was it, and what was the time? Bridge says, calling her for sale by owner. You're on the right track, but I need a little bit more details, Bridge.
Beth, can you repeat the question? I
Yeah.
didn't catch it.
Yeah, I saw it on your face. There was a time that agency disclosure has to be made different than for substantial contact. What was the time, or what was the trigger, and what was the time that it had to be made?
When the seller first contact with the buyer? Okay.
I like how you edited it, Brie. I'm like, I can't give you that. There's one. Folks, remember, if you are already a buyer's agent, you already represent a buyer client, and you are talking to, reaching out, communicating with a seller or seller's agent, you have to make the agency disclosure when?
Immediately.
Initial contact. Remember when we talked about seller sub-agency, and you understand the dangers. If I'm a agent calling a listing agent, there's a chance I could be working as a seller sub-agent on the same team. There's a chance I could be a buyer's agent on the opposite team. So because of that, if I'm a buyer's agent already, my loyalties are already to the buyer, I would have to disclose my agency status to the seller in the for sale by owner situation Bridge was talking about, or the seller's agent, as Bree was talking about, at initial contact. Everybody with me? And that is absolutely testable. Every other time, it's for substantial contact. Now, the other thing that I told you too, folks, even though it doesn't clearly state that we're going to confidential territory, North Carolina always tests it as, if you are showing the property to somebody, you better have already given them the working with real estate agents disclosure, because showing them a property means for substantial contact will happen, and you have to at least have an oral buyer agency agreement to show them that property. And if you didn't give them this, then we got a problem. Even if the conversation didn't go there, the commission says that's going to be the deadline, because you're going to be talking about pre-approvals and stuff. So remember, this is always step one when present. Explain how this works. Step two, form an agency relationship. Now, of course, we spent a lot of time on the buyer agent, seller agent, dual agency. So let's just give you the quick little recap here, folks. Of course, when I say buyer agency, that means we only care about the buyer. We don't care about anybody else. Seller could be unrepresented, or they could be represented by another brokerage firm. It's what we call single agency. We don't care about the other party. It's easy peasy lemon squeezy because there's no conflict of interest. Of course, we always also said that buyer agency could be oral to start, but even oral buyer agency agreements have to be what? And it says it on here, but I want you to use my language. What do I always tell you? There's really 3 things, but arguably 2 as well. Yeah, express, okay? You have to clearly state them. How is that going to show up on the test? That your oral buyer agency agreements would have to discuss compensation and dual agency. That's true, because that'd be part of express. So that's how that's going to show up on the test. So they have to be express, and they have to be what other 2 things? Well, that one. Like I said, it's right here on the screen, but I want you to use my language, not the language on the, nope, not written. Not the language that's on the slide. What did I always say? Nope, we already talked about stated. That's part of the express.
Open-ended.
Open-ended and
Non-exclusive.
non-exclusive. There you go. Thank you. Non-exclusive and open-ended. You cannot bind somebody to work with only you with an oral buyer agency agreement, and you are not setting a period of time in an oral buyer agency agreement. It is cancel any time. So they are always required to be expressed, clearly stated, including consideration, commissions, dual agency, what types of property, all that fun-filled jazz. When it would have to be reduced to writing, express. Open-ended, non-exclusive. I'm telling you, sure, in the real world, this may not be as much of a thing anymore with the NAR crap, but your test does not reflect the NAR crap. So you best know that oral buyer agency agreements are absolutely a thing. And of course, some of you stated this, it would have to be reduced to writing prior to presentation of an offer. You cannot get to closing in North Carolina with an oral buyer agency agreement. But let's go back to the throwback lesson. Is there a time that you could put in the offer on behalf of a buyer who was your oral buyer client, even if they don't sign a written buyer agency agreement? There you go. Yes, if you switch roles to a seller sub-agent. A seller sub-agent can put in an offer on behalf of an unrepresented buyer, but it is ill-advised to switch from that relationship because now any secrets we have learned about the buyer while we were in oral buyer agent capacity, what would we have to do with those secrets? Tell them to the seller. There you go. The seller. Love it. What you got, Raphael?
In that case, let's say the buyer tells you that he's willing to offer, let's say, $30,000 over the price.
Mm-hmm.
He doesn't sign it, so you become a sub-A agent.
Yep.
Would you be able to share that information with the seller?
Yes, you'd be required to share that information with the seller.
Cool.
Yeah. Which is why I would look at Raphael, let's say that I'm representing you in an oral buyer agency agreement, and you say, I love this house, I want to put an offer in, I tell you what I think you should offer, and you say, great, but I'd be willing to go $30,000 above that in case I, don't get it. I say, okay, sounds good, but let's try to get you a deal. And then you refuse to sign the oral buyer agency agreement, the written buyer agency agreement. I'm going to look you in the face, I'm going to say, Raphael, this is the stupidest stupid that ever stupided. If you don't sign this, I am going to screw you over. I have to tell you this, but if you say, I don't care, I'm going to switch roles and I'm going to send your offer over, but I'm going to tell the listing agent he'd go up $30,000 and they're going to try to take it to the cleaners.
So you before he signs, then I got to tell him that I can use information that he provided against him.
Mm-hmm.
I have to tell them that.
Yeah. Okay. Yeah. So it would not be advisable in any way, shape, or form, but if that's the route they could choose to go, we're going to screw them over. How about this one, folks? North Carolina real estate brokers do not have any fiduciary duties to their buyer until they have a written buyer agency agreement signed by the buyer. True or false? This would be false. Folks, agency is agency. Even in an oral buyer agency capacity, there are clients. The only thing that we just said in that last scenario is if they did not reduce it to writing and our allegiance then changed, we would not owe them fiduciary duties anymore. But in the time that we're in an oral buyer agency relationship, yeah, we're going to keep their secrets. We're going to give them old car, right? Obedience, loyalty, disclosure, confidentiality, accounting, reasonable skill and care. Remember dual agency. Raphael, put your hand up again. Is that another question?
Yeah, just a quick question. Is there any reason why someone would not sign this?
Yeah, because they're stupid.
Well, in general,
No, there's no reason.
Okay.
Yeah. Now, I mean, arguably in today's day and age, you know, when it maybe buyer agency commissions are not being offered on every property and they don't want to be on the hook for having to pay a buyer agency commission, you know, there's a chance that could be why. But, I mean, for most transactions, they just have to be nuttier than a squirrel turd. There's no real reason. But you still have to understand that that's the ramifications of this, right? And how this works legally.
Okay.
Yeah. So dual agency, folks, remember the definition, the way that you should default your brains to thinking about dual agency. Remember I told you, it is when the firm represents the buyer and the seller in the same transaction. I'm telling you again, do not ever think that it's just a firm that works with buyers and sellers. That's not true. Most firms work with buyers and sellers, but if we have 1,000 buyers and 1,000 sellers and they're not interested in the same properties, that's not dual agency. So it is the firm representing the buyer and the seller in the same transaction. We cannot do it without informed and written consent. And remember what I told you about dual agency. What did I tell you about it? You were what? Useless. Bound and gagged and useless. Can't say nothing about nothing to nobody. Because the firm represents everybody. There's this huge conflict of interest. And so you cannot advise or advocate in any way, shape, and form. And I mean any way, shape, and form. I don't necessarily think I gave you this understanding of it back when I taught it. But folks, think about this. You understood, and I think I picked on my friend Paige. And when I said, you know, I don't know, what do you want to offer? And she did the hair twirl for me and everything. Aside from that, if you get it under contract, even as Paige did with, I don't know, what do you want to offer? And I don't know, do you want to take this? What's going to be the next question the buyer and the seller are going to ask? The buyer's going to say, well, do I need a home inspection? Well, if Paige was to tell the buyer, yeah, they need a home inspection, who did that just hurt? The seller. And if the seller says, do I have to make these repairs? And Paige says, yes, who did that just hurt? Right? The seller. Do you see what I'm saying? So even outside of just the offer terms, any advice is going to screw you over in dual agency. Because if you are advising people to get home inspections, not get home inspections, ask for repairs, not do repairs, you're hurting one party, which means you're doing it wrong, which is why you really are worthless. But cannot do this without informed and written consent. And the other thing that I'll remind you of too, folks, when we sign the buyer agency agreement, when we sign the listing agreement, we get authorization for dual agency on the agreement. And they may give us authorization for dual agency from the offset, or they may not give it to us until later. But regardless, let's say that they give it to us from the offset. Are we automatically a dual agent just because they consented to dual agency? There you go, Brooks. No. It always starts as exclusive representation. And it would not be dual agency until it arose. And so if I was working with a buyer client who authorized dual agency, I would be giving them exclusive buyer representation until what? What would be the trigger that if I'm a buyer's agent, what would turn it into dual agency?
Consent from both parties.
Well, I mean, you would have to have that to have dual agency, but assuming that, you know, we have that, what would be the trigger? If I'm giving them exclusive, there you go. They want to see a house listed by my firm. That's it, right? Because if I'm a buyer's agent with ABC Realty and I show them a home listed by XYZ, Keller Williams, Coldwell Banker, Century 21, that's always exclusive representation. But as a buyer's agent of ABC Realty, the second they want to see a listing that is also with ABC Realty, now it's dual. And of course, I can't do that without informed and written consent of both the seller and the buyer. Now, one thing that I kind of talked about briefly in the last section, so I'll just provide the clarity. If you are dealing with oral buyer agency, you would start off with just oral consent to dual agency, because if you don't have a written agreement, you can't get written consent yet. Does that make sense for everybody? Listing agreements, the consent would have to be in writing from the offset, because they're always in writing. But buyer agency agreements, because they can be oral, buyer agency agreements. I don't want Jack to start getting froggy over there, so I'm going to finish that sentence there. They could start off with just oral consent to do dual agency, but it would have to be reduced to writing at the same time you reduce the buyer agency agreement to writing. What you got, Brooks?
So with dual agency, even if it is disclosed and say your buyer wants to see a house listed by your firm, right? What if the seller is already represented by the firm? Would that still be, that would transfer from dual agency to designated dual agency, correct?
No. Never automatically goes to designated, especially not for the testing world. And so, and let me paint a picture for you here. Brooks, you own a house as a seller, and I represent you as your listing agent. And if 700 buyers from other firms come and see your home, I'm still giving you exclusive representation. And then if Barry is a buyer's agent with ABC Realty, and even if y'all both consented to dual agency, if you haven't consented to dual agency, it really doesn't matter. If Barry goes and takes his buyer to go see, a home with XYZ, PPQ, Keller, all these different firms, those are exclusive. And while all these other buyers from all these same firms are coming to see yours, that's exclusive. But the second that Barry's buyer wants to see your listing, it's not automatically designated. You've got to default to dual. Now the firm becomes worthless. I can no longer advise you, Brooks, as a seller, and Barry can no longer advise his buyer, even though we could give you plenty of advice up until that point. The second this happens, obviously we have informed and written consent from both of you. We got to shut the hell up, right? We can't say anything. But if our firm practices it and neither one of us has confidential information about the opposite party, could we specifically appoint Barry to be the designated buyer's agent? Yes. And could I be your designated listing agent? Yes. And then we could go for blood. But don't ever treat it as automatic just because there's two licensees, especially not on the test.
Okay, because I think that's what tripped me up on the midterm. Just because I thought it was automatic, because the agents are already designated by the clients. So,
they're not. I mean, the designation, think of the designation as being by the BIC. The BIC would have to look at you and say, go for blood for the buyer, go for blood for the seller. Even though we are starting off going for blood for them in this exclusive relationship, the second dual agency arises, you got to treat it as worthless. Do not ever think it's automatically advocate. It's not. So in the scenario that I just played, I was advocating for you for 30 days. And Barry was advocating for his buyer for 25 days because we never had dual agency arise. But the second it arises, even almost a month into this, we now both become worthless to both of you and cannot advise you or advocate for you. And on a test question, the only thing that would contradict that is if I said the designated buyer's agent or was told to advocate, you would have to have some language that said you're going for blood.
Right. So when you say like absolutely worthless, like you don't mean for every offer. You just mean just pertaining to Barry's client, correct?
Yeah. And so I mean, obviously, if we never enter into a contract, it's not an issue. Technically, we're in dual agency as soon as you see it, but really it would be a super consequential thing if we get under contract with each other, right? Because if Barry sends an offer on behalf of his buyer and you accept it, now we're worthless for the entirety of the transaction. And we were also worthless for the offer and the acceptance. Yeah. And so Really, really important, folks. Don't ever put words into test questions that are not there. If it doesn't say designated, it's not. If it doesn't say advocating, it's got to use some language to tell you it's designated. Otherwise, you default to that worthless hunk of junk. I can't stress this enough. Otherwise, you'll get the questions wrong. So, I think we're good on this agency piece. And as I said, this is kind of just questions. True or false, provisional broker may serve as either a dual or designated dual agent in a real estate transaction per North Carolina license law. Yeah, true. However, while they can be a designated dual agent, we've already talked about, they cannot be. Remember the 2 times that designated dual agency is prohibited. One of them, provisional broker and their broker in charge specifically, cannot be designated against each other. And somebody who's already received confidential information about the opposite party can't be a designated agent either. Undisclosed dual agency is prohibited. We said dual agency is only allowed with informed and written consent. I'm not going to spend too much time on all these other things because, they're all stuff we've already talked about, and I want to get into some other review. Of course, the misrepresentations and omissions are going to be a big part of the test as well, making sure that you break them down and you can categorize them. Remember, these can be both willful and negligent. Willful, things you knew, you were aware of, you were told. Misrepresentations is you said something that was not true. An omission is saying nothing, and negligence is you didn't do your job right. So you got to be able to kind of break those down, and we gave you some examples of those early on. And so here's an example. Read this. Tell me what you think. Let me help you out with this one, folks. You've got to, this one is arguably maybe a little bit subjective, but a North Carolina seller, the seller is aware of an impending highway construction that will be built adjacent to their property and likely to decrease their property value. The seller makes no mention of this to their broker, who makes no mention of this to the potential buyer. The broker is guilty of. Don't put information in the question that's not there. But the thing is, folks, there is an expectation for us as brokers to discover all reasonably ascertainable material facts. And highway construction is something that you could ascertain. You would look at the DOT plan. So arguably, it would be part of the broker's job to find this information out. And if they didn't find it and ergo didn't disclose it, they are negligent in not doing their job right. And they said nothing, which is an omission. Remember, you cannot commit a misrepresentation unless you say something false. So they said nothing. It's not the broker said there's no issues. The broker said nothing. That's an omission. And they didn't do their job right. That makes it negligent. Everybody with me on that? Of course, the other big thing that was kind of in the discussions of material facts, of course, the things that were not material facts, and the things that are not material in North Carolina, haunted, whether somebody died in the property, sex offender lives nearby, all of these things of that nature. The 3 things that are always material facts in North Carolina: meth houses, polybutylene pipes if they've ever leaked, and synthetic stucco, also called EIFS. Exterior insulated finishing system. This is just depressing. Just can't say 5 words without just... EIFS, exterior insulated finishing system. So make sure you keep those straight. The other thing we said is, folks, you can tell somebody that a sex offender lived nearby. They're not a protected class. You can steer them in the right direction. You can obviously answer questions about haunted and death as well. We told you the only thing that you cannot talk about was that AIDS or HIV, whether somebody has had or died from AIDS or HIV, because that would be protected under fair housing, that disability or handicapping condition that we talked about yesterday. But the rest of them are not, protected, and so you could arguably talk about them. So how about this question? Provisional broker may disclose the presence of a registered sex offender in the neighborhood to their buyer client. True. Also, as a reminder, it's not going to be on my test, but I know it can and typically does show up on the state licensing exam. Remember, I told you the law in regard to the sex offender database is called Megan's Law. Megan's Law. If you see Megan's Law on the state licensing exam, it's still in the sex offender database. Other quick honorable mentions in the grand scheme of North Carolina stuff is, of course, the prohibited acts, the other things under 93A-6A1 that we said we're going to come back to. Making false promises will get us in trouble, subject to disciplinary action by the commission. Any undisclosed conflict of interest representing more than one party in a transaction without the informed and written consent. Improper brokerage commissions, like somebody being paid for unlicensed activity. Of course, the other one is a provisional broker being paid by somebody other than their broker in charge. Acting in a manner of unworthiness and incompetence as to endanger the well-being of the publics. Any fraudulent, dishonest, or improper dealings. All of these are prohibited acts in North Carolina, subject to disciplinary action and a hearing with the Real Estate Commission. Here's a question for you. An apartment company may offer the following promotion to tenants currently under lease contract. Refer a friend, receive 1 month's free rent. True or false? This would be false. Folks, real property for others for compensation. Here's the thing. You are offering money to somebody who already lives there for referring somebody to lease. So there's a brokerage activity, referring somebody to lease. They're leasing real property. It's not them leasing it, and they're getting compensation. That's a problem. They would need to be a licensed real estate broker to accept that month of free rent. Otherwise, it was being compensated for illegal brokerage activity. Let's change the question, though, to make sure you understand the testable differentiation. If the same apartment company offered 1 month of free rent to the new tenant, would that now be okay? Yes. Hopefully we all understand why. Now the tenant is renting the real property themselves. So it is not for others. Okay? It is real property they're renting. They are getting some incentive, but it's not for others. It's their tenancy. It's their rental. So this would be completely okay. A couple other honorable mentions as we're flying through some of these North Carolina review topics. Folks, remember the Residential Property Disclosure Act required what 2 forms on most transactions? MOG and RPODs. There you go. MOG and RPOD. So here's a supplemental question. Can the broker fill these out on behalf of their seller? Nope. Never, ever, 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 ever. If they need some guidance on what to answer, sure, we can help them. But the pencil has to pen whatever has to be in their hand. They're expected to fill these out. And remember, we said it is every real estate agent's responsibility to facilitate getting those to the buyer. And when does the buyer need to receive the RPOs and the MOG? There you go. Prior to making an offer. Beautiful. Does the real estate commission draft contracts for the agents to use, folks? No. Who drafts the contracts? All the standardized forms I taught you about. There you go. Bar Association. Yep, they're in conjunction with the North Carolina Association of Realtors. Nailed it. What 3 forms does the North Carolina Real Estate Commission author that we use day in and day out as real estate agents? WWREA, not the 2T, WWREA, and the 2 we just mentioned, MOG and RPOs, right? MOG and RPOs. This is just a matter of fact. We've already talked about this. We talked about the North Carolina Fair Housing. Any kind of violations of North Carolina or the federal fair housing laws would get us in trouble as real estate brokers. Fair housing always applies to real estate brokers and residential landlords. Remember, North Carolina, no unauthorized practice of law. Be very careful on the test. Could we draft up a contingency to put in a contract? No. Could our clients draft up a contingency to put in the contract? Yes. And we call it a party drafted addendum, right? We could do that. We can't make modifications because we're not a party to it, and to do so would be the unauthorized practice of law. We fill in the blanks, and if there's something that we want to get added in, typically we need to contact an attorney. Now, this is one that I promise you is going to be testable, okay? I promise. Both on mine and the North Carolina, I can almost guarantee it. Or like the state licensing exam. Advertising, the first 2, so-so. The first 2, when we're dealing with advertising, we would have to have consent from sellers to display for rent or for sale signs in the yard. We'd get that on the agency agreement. They give us consent to put the for sale sign, for rent sign. Also understand that provisional brokers are not allowed to advertise without the consent of their BIC. But the most testable one is the last one. Rule 58A.0105, which is the advertising rule, no, you don't even know the number, states that every advertisement has to contain the name of the sole proprietorship or the brokerage firm. It's more important than anything else. And the reason it is because if you were to look at an advertisement and you reach out and call somebody, you need to know that you're going to be talking to a real estate professional on the other side of that phone. That's the important piece. And if it's not present, it'd be a blind ad. So easy peasy for test taking purposes. If it lacks the name of a firm or lacks the name of a sole proprietorship, it's a blind ad. Nothing else really matters, just that. So if you look right here, which of these would be a blind ad based on what I just told you? There you go. A, because we don't know who Joe is. 3-bedroom, home, Surf City, call Joe. Who the heck's Joe? Is he the owner? Is he a real estate broker? We don't know. But C has the name of the brokerage firm, and B has the name of the broker sole proprietor. Now, of course, he'd have to be a BIC to be able to advertise that way as a sole proprietor, because any advertisement requires being a BIC. But arguably, these are both, B and C are both in compliance because they have either the name of the firm and or the sole proprietorship. I promise you it's going to almost always be tested as a firm, though. But just keep in mind that technically both are in compliance. If it just says Joe, if it just says a phone number, if it just says anything like that, it's a problem. It's called a blind ad. Blind ad. Of course, we talked about the delivery of instruments rule already. All instruments, documents, contracts, everything needs to be delivered to the appropriate parties immediately, but in no case later than 3 days. That has always been the case. Confidentiality of offers, which is 0115. Remember, we said this, no shopping of offers in North Carolina, meaning we cannot disclose the material terms of an offer, more specifically without permission of the person whose offer it is. So yet again, on the test, if we said that a broker could never disclose the material terms of an offer, that's not a true statement. But it's very seldom that it would be allowable.